excited to welcome you all to our panel today, focusing on litigation, fair share, and the climate responsibilities for governments and fossil fuel companies. My name is Delta Merner, and I work at the Union of Concerned Scientists, leading our Science Hub for Climate Litigation. Climate litigation is a growing tool used to advance effective action on climate change. Our panel today will discuss how climate litigation has evolved, we'll share perspectives on climate litigation in Latin America, and explore new scientific findings that can help to inform the courts. We are set up today as a 5-person panel. Each expert will introduce themselves and answer an initial question. We will also have time for brief discussion and some questions from the audience. All right, so we're gonna jump right in. Lucy, let's start with you. Please introduce yourself to the audience, and I'd love to hear your thoughts on the current state of climate litigation and how it has evolved over time.
Great. Well, it's wonderful to be with you today and our other panelists and the audience listening online. My name is Lucy Maxwell, and I'm a Senior Legal Associate at the Climate Litigation Network, which is a program of the Urgenda Foundation. And as some of you might know, the Urgenda Foundation is a Dutch sustainability organisation that successfully sued the Dutch government in 2015 for inadequate climate action. And on that basis, we support lawyers and communities around the world to bring similar cases against their national governments in relation to their mitigation ambition. So climate litigation as a field is really defined by its diversity, but I'll give you a sense of the kinds of cases that are being brought and what we've seen in the last 5 years, and particularly the last 2 years, because it's been a rapidly growing and developing field. So climate litigation really means a lawsuit in a court or tribunal at the national, regional, or international level in which the climate crisis is the focus of the proceedings. But you can challenge all kinds of different conduct, and cases are brought by a very wide range of actors against companies and governments. And I think what's important to keep in mind is that climate litigation can be both proactive, seeking to increase mitigation efforts, adaptation efforts, or it can also be quite regressive and try and prevent those activities from taking place. What we'll be talking about today, and I hope with the other panelists, is the proactive climate litigation, particularly one subset that we call fair share cases that challenge states or companies' overall mitigation ambition, and we can talk about that in a bit more detail. But to give you a sense of the broader landscape, cases are being brought by all kinds of affected communities. That includes young people, the elderly, First Nations communities, and they're being brought against national governments and major fossil fuel companies. The kinds of climate misconduct that are being targeted in these cases include, as I said, failure to do your fair share as a major climate polluter, but also other kinds of cases challenging individual infrastructure decisions like new coal mines and new oil and gas exploration, greenwashing in the case of corporate accountability. And what we've seen in the last 5 years is a real clarification through the litigation that's taken place for a decade or so of some of the core legal duties that are owed by states and companies. And that's really important because courts have accepted that existing legal obligations apply to the climate crisis, and they extend to mitigation and adaptation, and that they can be adjudicated by courts and held up against standards based on science, based on international law, and human rights in many cases. And a couple of the important decisions that I think we can go into in a bit more detail later in the panel, I'll mention 2 of them. One is the Dutch Supreme Court decision, which was in the end of 2019, the highest court in the Netherlands. They found that the Dutch state had a duty under civil law and human rights law to do its fair share of the global emissions reductions required to hold global temperature levels within a safe limit. And the court engaged with climate science on effort sharing, how to split the global carbon budget fairly. And it accepted that this was a standard against which the state could be held. And it ordered the state to significantly increase its mitigation ambition. And in a very similar style of case, but against a different kind of actor, a successful litigation was brought against Royal Dutch Shell this year, in which, once again, a court was happy to adjudicate whether that company was contributing in line with its legal obligations to the mitigation effort that's required to prevent dangerous climate change. And the court there found, again, that it was not, and it was willing to engage with questions of effort sharing and fair share, and it found that the company's fair share would be an emissions reduction of 45% by 2030. And so we see that courts are engaging with these difficult questions of distribution and mitigation action, and that's this one type of climate litigation, but an important type, and that these cases can have a significant real-world impact because we see states, as a result, changing their targets, increasing their efforts because of a binding court order. So look forward to more discussion about these cases.
Great, thank you so much, Lucy. Annalisa, can you tell us a little bit about yourself and build on what Lucy just said to help us understand the role of human rights in climate litigation and explain how human rights and climate litigation have come to really be connected?
Thank you very much, Delta. It's a pleasure to be here with you all. I'm Annalisa Savarezi, and I'm Associate Professor of International Environmental Law at the University of Eastern Finland. This is a topic that has acquired a great deal of visibility in recent years. As Lucy mentioned, there is a lot of climate litigation happening globally, and increasingly these cases rely on human rights. So if we are thinking about around 2,000 or more cases globally, about 120, 130 cases are relying on human rights. This is a trend that has increased in recent years on the back of the success, amongst others, of the Urgenda case that Lucy just mentioned. So what do human rights do? Why are they being used in this litigation specifically? I would say there is two elements to consider here. The first is that human rights are being used as a paradigm for climate action. So they're used as a yardstick to measure and assess how well state and corporate actors are performing in their activities to tackle the climate emergency. The other important contribution of human rights law to this area is the provision of remedies. As other panelists, I'm sure, will mention, in some regions, in some quarters of society, the impacts of climate change are already severe. At the same time, there is very little resort to remedies for these segments of the population that are already suffering severely for the impacts of climate change. So human rights law provides avenues for these applicants to lament and voice their concerns. For example, the audience may have heard of an important complaint by islanders of Australia whose land, or ancestral land, is going lost as a result of rising sea levels. These applicants have filed a human rights complaint against Australia. I'm sure that people have also heard about the children complaint before the Committee on the Rights of the Child. And this is another example of a group that is particularly vulnerable to the impacts of climate change and that has used human rights to formulate its grievances against the states that are responsible for this situation. I would add that, and I'm sure we have more time to discuss this, but I would add that human rights is not designed to deal specifically with climate change. So it's not a perfect tool to deal with this specific problem. At the same time, it's a useful tool because it provides, as I said, on the one hand, remedies, and on the other, paradigms that can be used in order to determine what states and corporate actors should be doing in order to get us out of the climate emergency. And this is what we are seeing increasingly and what we are likely to see more and more of in the years to come.
Thank you so much. Now, Florencia, could you tell us about the work that you're doing and give us an overview of climate litigation in the Global South? What are the main trends that you're seeing there?
Thank you very much. Well, first of all, good morning, good afternoon, depending on where you're watching us from. It's a huge honor to be part of this panel and discussing this such an interesting topic, especially when we are in the middle of climate negotiations that don't go as fast as we need them to go. So my name is Florencia Grin. I work for a regional environmental NGO that is called the Inter-American Association for Environmental Defense. So what we do is we use the law, national and international, and science to protect the environment in Latin America and the Caribbean, in that region. So as part of what we do, we've been forging a community of practice So what we want to do with this is sort of get all the people that are litigating in our region together, sort of make much better connections and find ways to make the most out of all the experiences that we're having. So climate litigation in Latin America is just, it doesn't have many years. We don't have too many cases yet. So we're in a very interesting moment to sort of do this and begin doing this in a way in which we can join forces all the time, because we believe that is very important. So as part of this community of practice, we are about to launch a climate litigation platform, which is something very interesting, and I'm very happy to tell you about, because it will be soon online and you will all be able to access and use it. And this is basically an interactive site on the internet where there will be information on all cases that are going on in Latin America, the ones that are already closed and the ones that are active. And there will be like filters and search engines, so you can sort of go inside the information and find whatever is more useful for you in a very interactive and friendly manner. We also want to make it like a platform where people can sort of connect. So you can, for example, get into contact with the scientists that work for a certain case, or the communities, the specialists, the lawyers, of course. So we have like we are looking forward to this, working and sort of making, keep working on our idea of sort of joining forces. And well, the idea of this litigation platform is also that it isn't something that we are like done by us. It's something that we are leading, but the idea is that it belongs to all the organizations that are litigating in the region. So that's why we've been very careful with sort of taking decisions with trying to involve everyone so that it really belongs to everyone. And then eventually, all these organizations that are litigating will be able to also feed this platform so that it's always updated with the latest news on whatever is going on in climate litigation in the region. So having done all the exercise that we've been doing with this climate litigation platform, we've been analyzing all the cases that are going on in Latin America, and I would like to show you some trends because I think they're very interesting. So I'm going to put a couple of slides there. So first of all, this is the total number of cases. It's 50 of them, and 31 of them are all active, and 19 have already been solved. So this graph shows how the growth trend. So the first cases started arriving around 2013, and then we got like 2 or 4 every year, new cases, I mean. And then by 2018, things started to spike up, and then in 2020, we had 13 new cases. So if we follow this trend, we might be getting much more cases in the future, which would be great. And then this is how the thing looks by countries. So by far, the countries that have more cases are Mexico, Brazil, Colombia, and Chile. And there are many countries that are just beginning to have their first cases. So that's really interesting to see also, and we're looking forward to all the countries having their cases, and then I expect this will sort of grow exponentially. Then when you think about who's filing the claims, so who are the actors doing these claims, majority of the cases are put forward by civil society organizations, 30% of them, and then there's also a lot by children and youth, and by indigenous peoples and communities. And these groups usually do their work like supported by NGOs. So you could say that most cases are very supported by NGOs, and that NGOs are doing maybe most of this work. Then as to who is being taken to court, so who are the defendants, the majority of the cases are against governments, central governments and local governments, and most of them are because of the vulneration of environmental rights, and also human rights, of course, due to activities that aggravate the climate crisis. The most common ones are cases to stop fracking, mining, deforestation, and atmospheric pollution. And then there's also a big chunk of cases that are also mainly against governments, that are always against governments, which is for their unfulfillment of international commitments. So something like the Urgenda case, maybe. So in fact, cases against companies are very, very rare. Not many cases against companies. Of all the 50 cases, there were only 7 cases that were like against companies and only companies, and then 8 cases which were against companies and the government. And these are like also, they follow the same trend of cases against sort of these very damaging activities such as fracking, mining, coal plants, etc. And the results, oh, maybe I didn't put that slide, but it doesn't matter. The results of this, no, I think that's okay. I'm going to just explain this bit. It's just the last one. If you want to know about the results, this is an interesting thing because of the 32 cases that have been, of the 50 cases that are going on, what I was going to say, of the 32 cases that have been solved, 16 have got a favorable decision and only 2 have gotten a negative decision. So this might be like a reason to celebrate, but unfortunately we have a big problem here, and we might talk about this later again, is that we have a very big problem with the implementation of sentences. So in fact of the issue that we are getting a lot of favorable decisions, most of them, very little of them get implemented. So in the end, the problems that are affecting the people are not solved. So this is something very important that we have to work on. Thank you.
Thank you so much, Florencia. Now let's dig in a little deeper to some of the cases you were just talking about. Danielle, can you please introduce yourself and describe how climate litigation is evolving in Brazil?
Great for the Delta. Hi, everyone. First of all, I need to do my self-description. I'm Danielle Farias. I'm a black man with a black haircut on the sides. I'm wearing black suit with a white striped shirt and a white tie. In addition, I would like to say that it's an amazing opportunity, and I'm delighted to collaborate with this important side event besides brilliant people. Instituto Alana is a non-profit civil society organization that was created in 1994 with the mission of honoring children. I work as a climate justice lawyer in the Children in Nature program, which has the purpose of defending the rights of every child to live in a healthy environment to strengthen your bond with nature. Despite of the scenario of the climate change and social environmental crisis has shaped a movement to transitional climate litigation for the Global South, which has addressed to the courts the necessary construction of climate justice in Latin America. And this construction of justice is formalized by climate disputes on the southern road is very different from what happens in Europe and the United States. Under this construct, it tends to be shaped by the peculiarities of the territory, which is marked by various vulnerabilities and inequalities and the special cosmovisions of traditional communities and social movements in the legal sensitives. Climate disputes are those capable of requiring the judicial and administrative instances to issue decisions that directly involve legal and faithful mentions that in the many have the causes of impacts of climate change. In Brazil, the growing number of climate litigation has played a role in movement in the judicial power to make enforce forces governments for different spheres and thus the most responsible for the climate crisis to contain the impacts of climate change and global warming. I brought some important cases to Brazil. The first one is Climate Fund and Amazon Fund. Political parties joining with 2 major actors, the Supreme Court, against the federal government due to the shutdowns, the Climate Fund and the Amazon Fund. The another one is civil society organization, partnership with political parties, joining with a climate action in the Supreme Court against the federal government to request the Great Deforestation Plan. And the third one is government of São Paulo was processed for financial fossil fuels. The movement called the Famílias pelo Clima joins a litigation action against the government of the state of São Paulo in view of the Incentive Auto program inaugurated under the current governor João Dória in 2019 to benefit automakers that install themselves in the state with tax incentives. More recently, NGOs go to court to do the government can present an executive plan that is consistent with the gravity of the climate crisis civil action targets, the national plan on climate change. Brazil updated targets to stop heating that we practically did not supply gases until 2030. In most of these cases, the Alana Institute submitted a request for the amicus brief to attest the harm caused by climate emergence for the rights children and adolescents who are the most affected. Thank you.
Thank you so much. Finally, Lavanya, I think we can all agree that there is a clear need for climate action, and litigation is one tool to help inspire that action. As these cases progress through the justice system, how can science assist the courts in determining if countries or other actors are doing their fair share? I think we're not able to hear her. Sorry, one moment, Lavanya. Are you unmuted? Oh no. She says she's unmuted. They're not seeing any settings on this side, so maybe just double check. I'm so sorry, everyone. Let's try to give another couple seconds to see if we can figure out the tech end. Do you want to talk at all about fair share? Well, while they're trying to sort out the tech to get Lavanya up and speaking, I think we're going to take a minute to have Lucy speak a little bit about the question that I just asked and discuss, at least give some definitions of fair share.
Sure. Okay, so a bit of background, I guess, to which might help the audience at home understand what we mean when we talk about a case that challenges a state or company's failure to do its fair share of climate mitigation action. What we tend to be talking about here is, as I said, mitigation. So it's really the amount of their annual emissions that are being reduced, and the cases tend to focus on the overall ambition of a certain emissions reduction over a time period. So a case would challenge, a lot of the cases that are happening at the moment are challenging states' nationally determined contributions, which are made under the Paris Agreement. So the commitment of a state to reduce its emissions by a certain amount against a base year and by 2030. And how communities are challenging those targets is by looking at a range of benchmarks against which to assess what the state is doing. There's a collaboration between scientists and lawyers that's particularly helpful because it puts states' mitigation efforts against both scientific benchmarks and legal benchmarks. So I'll talk you through a few of those benchmarks, and if we hear from Professor Rajamani, she'll be able to elaborate because she's the author of a very important new paper, which was a collaboration between lawyers and scientists. But at the moment, what plaintiffs have relied upon is scientific material, which is called effort sharing evidence. And in essence, what this is literature that seeks to divide the global carbon budget based on countries' historic contribution, their capacity to mitigate, and different indicators. And the effort sharing literature summarizes these different approaches and then provides ranges that a state should fall within in order to make a fair contribution. And so some cases, what they do is they present to the court this effort-sharing literature. And so, for example, the Dutch decision, which was filed back in 2013, and things have moved on quite a lot, but they were able to rely upon effort-sharing evidence that was in the IPCC's 4th assessment report. And that was a range of emissions reductions for developed countries over the period 1990 to 2020. And that gave a range of a reduction of between 25 and 40%. And they said, look, this is the benchmark against which the Dutch state should be assessed. What we see, though, since that time is that the evidence has moved on. And importantly, something that is now possible is to provide evidence of an individual country's fair share range, rather than one that was designed for many, many developed countries. And also one that has an indication of sufficiency, which prevents states from choosing the very lower end of their fair share range. Because if everyone did that, then you would far exceed the global temperature limit. And it's this kind of analysis that's been done by a number of different scientific organisations, which are available to the public and are being used by litigants in their cases. So we see that people are relying on the Climate Action Tracker and their fair share methodology. And that's been used in a number of cases that have been brought against states, particularly in the global north, because of their outsized contribution. But also, as I mentioned, an important new paper by Professor Rajamani at Oxford University and colleagues at the New Climate Institute and Climate Analytics. And that paper assesses the equity literature and those wide, often quite large ranges of emissions reductions that are provided. And it narrows the range, because what it does is apply legal principles that are found in the climate treaties that states have subscribed to. And it says certain principles that some people use to divide the global carbon budget are not in line with legal principles. And they include things that allow developed countries to take into account how much they've emitted and to continue a degree of that into the future. So notions of grandfathering, notions of cost efficiency, and they're not supported by the principles in the UNFCCC, the UN Framework Convention on Climate Change, or the Paris Agreement, which indicate explicitly that developed countries commit to take the lead in their mitigation efforts, and they have common but differentiated responsibilities, and that there's a notion of equity, which means that developed countries must do considerably more than other countries. And so with that analysis, that fair share range reduces significantly. And then they also check sufficiency. If everyone did, within their shorter range, what would be needed if everyone has to do their fair share to stay within the temperature goal? And that paper is available online, it's open access, and we can share some materials with the community after the event if people are interested. And that's really going to be crucial evidence in litigation against states. And similar reasoning could be used against companies, but that will be crucial.
Yeah. Well, thank you. Thanks everyone for kind of sharing your initial views and the work that you're doing. We're all working on climate litigation, but certainly come from different perspectives, views, and different expertise in that. We've heard a little bit about where climate litigation has gone, and we want to take a step to also hear a little bit more about the future. It looks like we do have Professor Lavani now. So can we pull her back up? And I'm not sure if you were able to hear the comments that Lucy had, but hi.
I did.
Oh, wonderful. It's good to see you. Would you like to introduce yourself and add anything to the conversation? Yeah.
Sure. Thank you, first of all, for having me. It's wonderful to be part of this fascinating conversation and terrific panel. You couldn't hear me initially, but I could hear all of you. So it's very much a sort of fascinating conversation I'm very glad to be part of. My name is Lavanya Rajamani. I am a professor in international environmental law at Oxford University. Lucy's done a fabulous job of presenting our research, but if I could just add a few little details to it and take a few minutes, not very much. What we tried to do in this paper, as Lucy explained, is to determine fair shares in a scientific and legal rather than a policy prescriptive and political way, because we believe and hope that this will help national and regional courts assess if states are actually doing enough. The issue of each state's fair share in addressing climate change is central in many of these cases, as Lucy so lucidly explained at the start and even right now. Because when litigants go to court and claim that the national action is inadequate or that state is not doing enough, you need a benchmark to determine if that state is not doing enough in the context of a global collective action problem. And that's exactly what we try to do in our research. The Paris Agreement doesn't give us those kinds of benchmarks for each state because it is ultimately nationally determined actions and not internationally negotiated. So there is no internationally negotiated burden sharing arrangement. If we had one, the issue of fair shares would not be left to courts, national and regional courts. So we don't have that. What we have is a good faith expectation that states will actually adopt nationally determined contributions that reflect their fair share, but there is no obligation to do so. So when we looked at NDCs and we looked, and part of our research method was to look at the whole spectrum of NDCs. We looked at 168, which includes the EU NDCs up to the end of March 2021. We tabulated all references to principles of international environmental law. We tabulated all references to objective indicators that states had cited in their NDCs as reflective of as narrative justification for their fair share. But what we found is that many of these indicators that states actually cite for themselves, and the scholarship actually cites, are indicators that are self-serving and don't actually accord or are not anchored in principles of international environmental law. So to give you examples of indicators that are not anchored in principles of international environmental law, for instance, small share of global emissions. 101 NDCs referred to the fact that their emissions are a very small share of global emissions, and therefore, whatever they do is fair. However, if you add up all the emissions from these NDCs, it accounts for a third of global emissions. So clearly, that is not an indicator that is a fair indicator, determinant of whether a state has fair shares or not. Also, least cost pathways. Many NDCs refer to the fact that they're adopting the least cost pathway to reducing their emissions or the ambition of their ambitions. But least cost is relevant in implementing a fair share. It's not relevant in determining a fair share. And we look at principles of international law and analyze these indicators to see which ones can actually be excluded. And if you exclude these indicators, we find that there's a much narrower range of fair shares that each state is entitled to sort of exercise its discretion within in terms of determining its nationally determined contribution. But there is an interpretative range even with that fair share. So we then looked at references that states had made to the highest possible ambition, to progression, to human rights, to suggest that actually all fair share ranges should be to ensure that we got to a well below 2 degrees temperature rise, and indicated as a purpose of the Paris Agreement, and to 1.5 as well. So when we do that, we find that the fair share ranges of states are far narrower in a sense. And in our research, and if you look at the paper, which is an open access paper, online, was published in August in Climate Policy. If you look at this work, you'll see that we have fair share ranges for every state. For most states with high historic responsibility, that is high GDP per capita, etc., they end up with a Paris-compatible emission level in 2030, which is actually net negative. So Germany, France, UK, USA, Japan, they need to be net negative in 2030, and that is not the direction that they're going in. Of the G20 states, only India and Indonesia have a fair share range that is actually higher in 2030 than 2010, and only India higher than today's level. But to reach the Paris Agreement temperature goal, global emissions in 2030, as we know, would need to be well below 2010 levels, 45% below. And the latest NDC update synthesis from this week suggests that we're currently on track to 13.7% above 2010 levels in 2030. So clearly we are not where we need to be, and states are not doing their fair share. What our work seeks to do is to offer a benchmark for states as they submit their nationally determined contributions under the Paris Agreement for what their fair share is, offers a benchmark for peer and non-state actor reviews of the adequacy of NDCs. We are hoping that this kind of analysis will feed into the global stocktakes, but also that these results can actually inform climate litigation in national, regional, and even international courts. Because in the ultimate analysis, states' actions on climate change are not to be assessed solely on the basis or pragmatic basis of what they're willing and able to do, which is what we seem to be expecting states to do, but there is an international framework which poses principal limits on national determination. And we draw on these in this paper to actually determine fair shares for states, and we're hoping this will be useful for courts. Thank you.
Well, thank you so much. What's so powerful about the work that you do is it really helps us to think about some of the future of climate litigation and where we can be moving forward. I'd love to hear from some of our other participants about that same question, to think about what is the future of climate litigation and how does it apply to the work that you're doing yourself. So let's start with Annalisa. Yeah, we're just going to have a kind of large discussion and everyone address that question.
It's a very important question to ask at this moment because we've had a first wave of climate litigation in recent years that has set important milestones that Lucy was describing and Florencia was outlining how this is happening at a global scale. What's coming next is, however, I would argue even more important because climate law at the international, but also at the national level, has clear gaps concerning the accountability of state and corporate actors. So litigation is crucial in putting a remedy to these gaps. What do we need is greater and better legislation that is consistently and stringently enforced. And litigation is the tool through which we can get there. So really, the cases that are being litigated all over the world are pushing lawmakers to do a better job on climate change than they have done so far. And Lavanya was clearly outlining how there are principles and criteria that can be used in this connection. And litigation is the tool that we can use in order to push them to just do that. It's a long game. It may sound like a long game, but we have to remind ourselves that climate law is a relatively new creature. And it's part of the physiology in the evolution and coming of age of a branch of the law to equip itself with better accountability mechanisms. So we are now in this crucial phase in the life of climate law of devising tools that are adequate to deal with a massive crisis we are experiencing. And I think that there are proxies that we can use and have been used as a term of reference, but it's also true that this magnitude of a problem is posing new challenges. And this is what we need lawyers to think creatively about ways in which to deal with this problem. Human rights law can help. There is a lot of environmental jurisprudence in this area in Latin America, for example, that can inspire judges and litigants. But it's also true that we really need to focus on the specificities of the problem at hand and the deficiencies of the international cooperation mechanisms that have been designed and how these can be felt at the national and regional level. So litigation is really crucial. It's really hard to overstate, for example, the importance of the milieu defense case that Lucy mentioned, because here we are looking at an enormous gap. Corporate actors and their activities in this sector are arguably more important than the activities of states themselves. And we have very little that can be used yet to bring these actors to task. And this is what the milieu defense decision did in a very interesting and important way. We'll, of course, have to see what's coming next, but we are really at the beginning of a long and important story that's yet to be written.
Wonderful. Lavanya, do you want to add anything for kind of future of climate litigation?
Yes, thank you, Delta. Just to add to what Annalisa has already said, I think over the last decade or so, there has been an exponential growth in climate litigation, but we're still at the beginning, as Annalisa says. It's set to grow even more. Many have described the sort of coming years as sort of representing a phase in which there'll be a tsunami of climate litigation. But there's still relatively few cases in international courts and tribunals. A couple of cases in the Human Rights Committee, one in the Child Rights Committee that Annalisa has already spoken to. But now there's an initiative by Vanuatu to move the General Assembly to seek an advisory opinion from the International Court of Justice. And if this comes to pass, and we do get a progressive opinion from the International Court of Justice, it will fundamentally reshape, I think, the landscape of climate litigation going forward across multiple levels. By progressive advisory opinion, what I mean is an advisory opinion that actually clarifies and brings much needed clarity, really, to the nature and legal extent of legal obligations as a whole that states have in relation to addressing climate change. And this has tremendous potential to enhance climate action and also to influence the shape of climate litigation across multiple governance levels for at least three reasons. First, it can signal firm legalization. The Paris Agreement, in many respects, is seen to be a result of pragmatic deal-making among states. And its legal character is often called into question and even dismissed at times. So a strong opinion on the legal rights and responsibility of states will place vulnerable states on a much firmer footing and generate additional pressure on major emitting states as pressure that we need, not just in terms of mitigation, but also support and possibly loss and damage. It can also, and this is a second, I think, sort of significant sort of value add it can bring, it can concretize legal obligations. So there is considerable interpretative ambiguity in the Paris Agreement. And this was, of course, negotiated to the extent that provisions of the Paris Agreement can be interpreted in the light of general international law and other areas of public international law, can actually concretize the legal obligations of states. It can give states benchmarks to assess their own actions. For instance, if a standard of due diligence is created and shaped and put forward for what states should be doing. And finally, it can also bring cohesiveness in a very fragmented field. The Paris Agreement and even the UNFCCC regime more broadly is not the only set of legal obligations states are subject to in relation to climate change. They have obligations in general international law, in particular relating to harm prevention, which is a rule of customary international law, associated duties of due diligence that I've already alluded to. We have obligations in relation to good faith and cooperation. There are normative expectations in relation to principles of international environmental law, including equity, both intra and intra-generational and common but differentiated responsibilities. And there are obligations in other areas of public international, including human rights law, which Annalisa and others have also referred to. So a clear and comprehensive enumeration of rights and responsibilities of states in relation to climate change would be a game changer, I think, in future climate litigation across levels of governance. Thank you.
Wonderful, thanks so much. Florencia, we'd love to hear from you.
Okay, so I think climate litigation is something, it's so important. It's a key tool in the toolbox of climate justice. And I think it's very important, everything that is going on. I'm really happy to hear about all these studies, all these new ideas, all these strategies. And well, I'd like to bring a little bit like the view from the South, because it's also interesting to sort of see the trends of what's going on in the United States and in Europe, and then see what's going on in the least developed countries, because it's totally different. And I think we can learn a lot from each other. And in the end, we are all towards the same cause. So I wanted to, while doing all this climate litigation platform work, we came up with sort of the main challenges, which I think is something very interesting to talk about in this point. So I'd like to sort of walk you through some of them, because I think this is good to sort of think about what the future should look like for climate litigation. So first of all, we've seen that climate litigation is an amazing tool, but it sometimes also brings unwanted and unexpected consequences. So I think we should always have that in mind. This is maybe more the case in where there are more vulnerability, so as to say the global South. So one thing that happens in Latin America, which is really, really sad and terrible, is that it's the region where there are more murders towards environmental defenders and towards human rights defenders. So there's a report of the Special Rapporteur of the Situation of Human Rights that came out in 2019, and Latin America from 2015 to 2019 was always the record place where more killings were being taken place. And from all the human rights defenders, by far the ones that are being more affected by these are environmental defenders. So that's a big, big problem. We are facing more than 1,300 murders from 2015 to date, according to this report. And obviously, when there are these cases, it makes people more sort of a target, an easy target. So that's one big problem we should have in mind, and we should sort of work on, because it's terrible, obviously. And then another thing that is really, really sad is that sometimes these cases bring the fragmentation of communities. You know, these local communities, especially the ones that live like in very traditional ways, indigenous communities, etc., can be very damaged by, for example, companies that come in and then try and buy some of the leaders, for example. And that is something they do not only because they want to buy them and able to do their project, because they know that if they buy half of the community, they will totally disrupt their social fabric. And this is very, very damaging and very difficult to sort of repair. So that's another problem. Then there's another thing that is the emotional stress and stigmatization of plaintiffs. And this is, I think this has to do a little bit with a lack of resources that there is in the South to carry on these cases. So I was thinking about this the other day that I was talking to a lawyer in Australia that had been part of a very important case in Australia, and he was telling us that this case was put forward by youths and children, and that they had done like an incredible job in accompanying these youths and children so that they didn't sort of suffer any stigmatization and even any sort of depression by the possibility of the case not fulfilling their expectations. So they had like a team of psychologists coaching, they followed up on them, and it was great. And we were like, oh, it would be amazing to be able to do that. So those are one of the things where you can see like the differences between doing things with more resources and doing things with less resources. Then another thing that is really a big problem is the power inequality among counterparts. I'm sure this is the case in all the world, but the gaps are bigger in the southern world. And obviously, companies and governments, which are usually the ones to be sued, have much more power than the vulnerable communities and the NGOs that are putting forward these cases. So there's an inequality in terms of political power, technical power, economic power, etc. Like companies can even pay for scientists that will dismiss our work that has taken us years and years. So we also have to be like very prepared for this, and this has to do also with capacitation, with like having the resources, and also to sort of joining forces, which I think is the key to many of these problems. Then there's challenges in the construction of cases in itself, and one of them is the burden of proof. So in like the general law, in the general rule in cases is that the one that says the fact must prove it. And it's pretty hard to demonstrate the link between the impacts of climate change that are aggravated by something that the company or the government did, and then link that to the violation of environmental or human rights. So that is pretty difficult, and it needs like a lot of work, scientific evidence, etc. Fortunately, I think we're getting better in this because scientific evidence is now more accessible, more robust, and there's less sort of denialism. So I think we're moving forward in that aspect, but it's also something to have in mind. Another problem that is very, very critical in our region, in some countries of our region actually, is the difficulty of accrediting legal standing. So, for example, the worst case now is in Mexico, where there's like contradictory jurisprudential criteria. So, like organizations file cases, and it's pretty random if they will get admitted or not. And for example, we had a case of Greenpeace, where they were suing the government because they had sort of passed a law that was less ambitious than what they had. And the judge resolved that Greenpeace, being an organization, was not entitled to environmental rights. So they were not allowed to file the case. Imagine, that's really, really serious, because these organizations are the ones doing the work. So, well, this case is being appealed, so we might have good news soon, but that's another thing, like those kinds of procedural obstacles that we see. Another problem that is very common in very terrible and something that happens in Latin America, in other places as well, obviously, is corruption. And this is sort of dangerous because proving corruption and fighting against it is difficult and dangerous. So that is another problem that we have to have in mind. So this excessive power that companies have against states, governments that are much weaker sometimes. So it's really difficult to sort of balance the power there, and then you get corruption, and then you get all these problems. You don't have sort of enough power in the judicial system or in the regulatory framework to sort of fight them back. And the thing is that these countries are poor, so they sort of need these transnational companies. And when they finally get rid of them, if they get rid of them, these transnational companies go to another poor country that needs them. So that's another reason to say that we sort of need to join forces, because if not, we're going to be stuck in the same. And finally, the final thing that I wanted to say was talk about a bit about the implementation of good decisions, which was something that I had mentioned before. This is a big, big problem, and I think one of the ways to sort of deal with it is planning cases, sort of thinking about the possible sentence that you want, and sort of designing the way that that is going to be implemented right from the start. Because in the end, you do all this work, you get a positive sentence, and then the work doesn't end there. And you end up sort of trying to put much more resources and time in trying to get the problem solved without any success. So that can be sort of very, very problematic. And I just wanted to share, I'm taking on my time. Just wanted to share one example sort of to exemplify this problem. There was a very famous case in Colombia in 2018 filed by a group of a group of young boys and girls. It was, they were suing the government of Colombia because of deforestation in the Amazon. And they got a beautiful decision. The court said that the Amazon was subject to rights. So the Amazon was subject to being taken care of just because it was the Amazon. So it's beautiful. But in the end, deforestation didn't decrease at all. So like you have these beautiful decisions that sometimes even sort of take the burden off the judges. They are like, I did my job. But then the problem is still on. And we don't know, and we haven't been able to sort of to use those decisions to really take care of that really, really serious problem. So yeah, that's it.
Wonderful, thank you. Danielle, will you share some thoughts?
I just pointed to aspects. The first one is, with the evidence of the climate injustice around the globe, and with the epicenter in the global north, there is a movement towards the global south, which compiles a new society's structures and necessary decolonization of the dimensions of the justice, adopted the characteristics and needs of the south. Latin America as a space marked by legal pluralism and by the source of lowering knowledge of native people and traditional communities. Another aspect is mobilization of these climate disputes for the international sphere of the Inter-American human rights system, which recognize through opinion advice the indirect relationship between human rights and environment, particularly applicable to the vulnerabilities of the children and the indigenous people. This is an important step for climate litigation under conventional control, understood and analyze of the compatibility of the domestic law with the international parameters of the human rights. Thank you.
Wonderful, thanks. Lucy, do you have any additional thoughts on this?
Yeah, no, it's really interesting to think ahead. And I just wanted to say, I think, Florencia, your points around the dangers that are faced by environmental defenders in different countries and the challenges of implementation are just really important, I think, for all of us to be aware of. And I think those of us who aren't facing those kind of security risks, I think we just need to take stock and be thankful and work as allies for those who are, because I think it's a really important reminder. And with that in mind, I think the kinds of cases that we're working on are specifically against global north governments because of their contribution to the climate crisis and how much they need to do and the gap that remains. And so I think that's, from an ethical point of view as a lawyer, that's where we're trying to really push what we can in the jurisdictions where we can act. But I think the two developments we'll see really coming through is who can bring cases. And I know one of the panelists may speak about the recent decision of the UN Committee on the Rights of the Child, but perhaps one way of bridging this gap between affected communities, like the most affected communities, and the actors that are most responsible is through an expansion of states' extraterritorial jurisdiction, which sounds like quite a technical legal concept, but very basically what it means is expanding the groups of people who are able to bring a case against a government where they're not living in the territory of that government. And I think this is particularly important for a problem like climate change, where the effects are felt around the world. Even though their emissions are released in one place, the effects can be much, much, much worse somewhere far away. And the recent decision of the UN Committee on the Rights of the Child, I think it's honestly a couple of weeks old. And while there were some concerns about the final outcome. I think one really important element of that decision, which is by a UN treaty body, so it's not a court, it's a tribunal, but it's very important. It adopts an approach to the people for whom a state is responsible for that draws upon the Inter-American Court of Human Rights advisory opinion. So we see this transfer of norms between courts and tribunals, which is really powerful. And it says that the test for your responsibility as a state is whether you have effective control over greenhouse gas emissions. And if you do, you're responsible for those emissions and who they harm, even if they may harm people who are outside your territory. And that's really just quite revolutionary. And I think it's honestly, yes, I said a couple of weeks old, and we're haven't seen how that will play out in the courts in the global north. But I think it's a real mark of a beginning of expanding that notion of who can sue whom. And in terms of what people might be sued for, I think what we'll see, and I'll just touch on a couple of perhaps some looking ahead developments. One, I think, will be many more cases in which courts engage specifically with the question of adequacy of mitigation ambition. We've seen huge development in the last 5 years, in the last year really, in these kind of court decisions, with a number of the preliminary building blocks being established, the existence of legal duty and standing and jurisdiction. But what we really will see, building on that landmark Dutch case and a recent German decision, is engagement by courts with the question of fair share. So that's one development. The other one, in terms of what people will be sued for, is how states and companies are engaging with their fossil fuel resources. We've had a number of breakthrough judgments in the last 2 years. One indicating that permission for a new coal mine in Australia should not take place. Another that a Commonwealth minister in Australia has a duty of care with respect to her statutory power as to whether to approve a new coal mine or not. But this is just the beginning. There have not been that many cases in which states have been prevented on legal grounds from exploiting and exploring new fossil fuel reserves. But the scientific evidence is so clear that they must stay in the ground if we are to have any chance of 1.5 degrees. And I think that's the next frontier. Many more decisions affirming that scientific reality. So those are the kinds of things I hope that we see much more of.
Wonderful, thanks so much. So we have about 15 minutes left, and I'd love to move into just some questions and answers with this wonderful panel. So to start, throughout the course, a lot of different folks have mentioned human rights and kind of the role of human rights in this work. I'd love to hear a little bit more about what Lucy just brought up and really get some other opinions on the decision of the Committee for the Rights of the Children and for that complaint. Maybe we can start with Danielle.
Firstly, we need to recognize that climate crisis as a children's rights crisis. The role of the irradiated children population, the spheres of the power to modify the current climate emergency has given new controls of the climate agenda. The democratic exercise of climate citizenship with strike action, protests, mobilizations, and climate litigation are strategies for the contribution of the children and adolescents, being essential for the resumption of the climatically stable standards to resistance for a society that is aware and concerned about the future of the present and successive generations. The voices of children actors should announce the climate crisis have reverberated in the world context, but very little are priorities designed and the truth for children and adolescents in this growing scenario of the climate disasters around the world. There are countless children and adolescents intersected by race, gender, and classes spread across different vulnerable and inequality territories of traditional communities and peripheries really affected by climate change, and the defense of these segments is central to any concept of the climate justice. The search of the social environmental rights to a stable climate and born the street are anchored in the climate social movement exercised especially by children and adolescents when they protest and they strike, where they mobilize to feel complex to engage force in public stances, is cooperation between families to active to justice systems and other actors that are aligned with the climate activism of the children and adolescents. To address the confluence of climate governance, prioritize and then carry out by themselves. The legacy that children and adolescents have a level of contain the climate crisis is unquestionable, as these actors are the most vulnerable and are also protagonists in the change this really. They have become inspirators for their time, demonstrated great deeds, and be remembered by history. The climate activism of the children population exercised on the streets and the sense of the power can be considered an intergenerational instrument to embrace climate justice. Fortunately, the COC Committee ruling of jurisdiction does provide a robust basis for the further guidance on the state climate obligations in the future cases, as well as in the 14th general commitment, the eyes of the world will turn remains of the committee as it continues to grapple with the important role of protecting children's rights in the face of the climate crisis. Thank you.
Thank you so much. Annalisa, do you have any additional thoughts on the recent decision for the Committee of the Rights of the Children, the complaint by Sushi?
Thank you, Delta. This is a very interesting example of what I was saying earlier about human rights not being designed to deal with this type of problem specifically, and therefore being imperfect tools for the climate litigation that we have been discussing in this webinar. The committee basically agreed with the applicants that they had genuine human rights concerns associated with the climate emergency, but was prevented from adjudicating on this matter in the merits, if you like, by its rules of procedure because the applicants had not exhausted domestic remedies. This is a common hurdle in human rights-based litigation before bodies such as this. This was not a judicial case, as Lucy has already explained. Yet, the importance of these complaint mechanisms is well recognized because they are authoritative, they give visibility, and they are putting pressure on states to do better. So the fact that a committee like this, on procedural grounds, didn't proceed to adjudicate on the merits of a complaint of this kind is not a nice signal. Yet, if you look at it from the perspective of a human rights body, you can understand that they were reluctant to throw away, as it may be, the rule book concerning access to the committee itself and really bend the rules to accommodate the plight of the applicants. It's true that committees like this have powers to exercise discretion in bending the rules, as it were, but they decided not to do so in this specific case. We can have a conversation whether or not this was a good idea. What I would say is that there is a similar issue presently before the European Court of Human Rights with another children case. It's going to be interesting to see whether the European Court, which is a proper judicial body, will adopt a similar approach or if it will follow the example of the Committee of the Rights of the Child. What I would say is that we shouldn't be discouraged by these precedents because they are just showing us the limits of the existing legal order and what can be done in order to overcome these limits. So it's important to have these test pilot cases and see exactly what can be used and what cannot be used. We have referenced to gender and media defense many times. They are very good examples of how the law as it is has been successfully used by litigants. We have examples where the law is not being successfully used, but these are equally important to understand exactly how do we go about bridging the accountability gap that I was talking to you before.
Wonderful. I saw some head nodding from both Lavanya and Lucy on that. I do want to ask you a different question, but feel free to also comment on the UN decision if you want. So For either Lavanya or Lucy, I'm curious to hear a little bit more to see if you have any additional thoughts on applications of the fair share approaches that you're talking about, specifically to inform some of the work in the Global South, some of the examples that we're hearing from our colleagues today, and also a little bit more about corporate actors. So again, it's something that's very global, something that we're looking at expanding, and I'm curious to hear about how fair share fits into that. Lavanya, do you want to start?
Sure, Delta. But I do want to jump in a little bit on the, not so much on the case itself that you've just been discussing, because Lucy and Annalisa have covered many of the sort of critical points, I think, and it is just a few weeks old, as Lucy said, the decision. So there is much to process and think about as we go forward. But I did want to pick up on the issue of intergenerational justice and the issue of future generations as well, in the context of, I think, the third kinds of, or to add to Lucy's list, the kind of cases that we hope are going to come up and that are going to come up, we see when we see numerous announcements on net zero targets, and we've seen many of these announcements even earlier this week. And if you add them all up, the IEA, the quick sort of back of the envelope sort of exercise tells us it will put us on path to 1.8 degrees centigrade. But we look at the NDCs, and we're 13.7% above 2010 levels. In 2013, we should be 45% below. So it's clear that short-term actions are not aligned with long-term goals. And in fact, some of those long-term goals, including the net zero targets, we don't even know whether they are CO2 net zero targets or greenhouse gas emission targets. So there are a lot of questions around credibility and accountability and fairness of these net zero targets. But there is also a very strong intergenerational element to this, which came out in the German Federal Constitutional Court decision earlier this year. So precisely because all hard choices and difficult choices are being postponed to later years, there is an intergenerational shifting of the burden, which was brought up in the German Constitutional Court case, but I'm expecting that this will be brought up in the context of accountability and credibility of net zero also in other cases. I think this is a very important part of the puzzle. It's not just shifting of the burden with respect to taking climate mitigation action and leaving hard choices for the future. It's also shifting of the burden of carbon dioxide removal, so which is very expensive. So there are also sort of huge financial burdens that are being shifted to future generations. So I think this is a third type of sets of cases that are going to come up going forward. And the fair share question comes up also here, because there's sort of relationship between intra-generational equity and intergenerational equity. And I think there is scope for the fair share research to go beyond, to look at the sort of temporal element as well, to see, well, these are the fair shares today. What would be the fair shares tomorrow? What are the fair shares between generations in the global south and the global north? These are the kinds of questions that crop up in the context of this dissonance between long-term net zero goals and short-term inaction, really. Thank you.
Wonderful. Lucy, any additional thoughts?
Yeah, thanks. I would absolutely echo what Lavanya was saying about the fact that accountability around these endless net zero targets that are being announced is going to be crucial. And I think an interesting recent case, once again out of Australia, is the first case to challenge a company's net zero announcements. And that's, I guess, a variety of greenwashing cases, which have been brought for many years, challenging allegedly misleading or deceptive statements made by companies about their environmental credentials. But I think what's really interesting is that we're going to get into the nitty-gritty of net zero targets, because companies as well as states are announcing them. And this particular claim is against Santos, a fossil fuel company. It's under corporate law and consumer law, so designed to protect investors or protect consumers and ensure that statements are made are true. And the first claim that's being challenged is that Santos is saying that natural gas provides, quote, clean energy. And the second claim that's being challenged is that Santos has a, quote, credible and clear plan, end quote, to achieve net zero by 2040. Now, this is going to be incredibly interesting to see how a court handles the testing of the veracity of a claim like a plan to net zero. And there's been some really important recent research, also out of Oxford and a number of other institutes, regarding benchmarks for net zero commitments. So we were talking earlier about benchmarks for assessing fair share. This is a different set of research. Once again, scientists coming in and indicating for a robust net zero target, it should have this coverage, it should have this accounting mechanism, it should have these kinds of features, which is absolutely fantastic. That's exactly what communities need, because often it's quite hard to know where to begin to start critiquing those kind of targets. So I think that'll be really interesting, and only echo what Lavanya said about intergenerational equity and where the burden of mitigation is placed and on who it's placed. So I think that'll be, yeah, very important as a component of these cases in the years to come.
Great. So for our final question, so we're talking a lot about the different targets of the litigation and what that's looking like. And Florencia, I know in your presentation you talked about a few cases that you're starting to see against companies and corporate actors in Latin America. We see that a lot in the US and successes in Europe around those cases. I'd love to hear a little bit more about if you see that this is think this is a trend that will kind of follow through in Latin America, if there'll be some growth of similar cases there.
Thank you. So I think that it's very important that there is a growth in these kinds of cases, because definitely companies have many times transformed into these like huge monsters, and we really need to put them like back where they belong, like private actors, but not so powerful. They are really overpowering our governments like by far. So this is something that is critical to sort of address in order to solve this climate crisis, especially when these companies are the ones producing all these greenhouse gas emissions. So, but the problem, as I was saying, in Latin America is that there's not enough of a legal and judicial framework to fight against these companies, and the governments are not strong enough to fight them. So, for example, there's a problem with governments are afraid of being sued back by these companies even. So they are really like, they have like their hand on top, But I guess this has to follow the same trend, and as Laura was saying, we need to sort of join forces, because in the end we're all in the same planet. So because like the global north is starting to be more effective in these kinds of actions, I'm sure we're going to be able to follow through and sort of get there. We have to start building like stronger regulatory frameworks. International law on climate change is really good, and the more that we do this climate litigation, the more that we use these international laws, the more strength that we give them. So I have faith, and I'm positive that this will become a trend as well in Latin America.
Wonderful. Daniela, do you have any quick thoughts on the same question for Brazil?
I'm not sure about the questions. I would like to have the passages opportunity to another person to answer.
Okay, great. Well, so that wraps up our presentation today. I want to thank all of our panelists and everyone who joined us virtually for this important discussion. Regardless of the outcomes of the negotiations here at COPs, I leave this session knowing that climate litigation is a growing and powerful tool to help ensure that we can achieve the changes that we need. If you'd like to learn more about climate litigation, you can visit the Science Hub for Climate Litigation at the Union of Concerned Scientists. From there, you can access a number of different resources around climate litigation, and you can also get in contact with me, and I can get you in contact with any of the panelists that we had today, and also share their information with you. So if you want to learn more about the resources that were presented here today, if you want links to the studies, to any of the wonderful information that was shared, please reach out to me through the website, the Union of Concerned Scientists. So again, thank you so much, and I appreciate everyone joining.